All right, folks. This is Douglas Pinkham with Pinkham and Associates. We are a dedicated family law firm in Orange County, California. We practice nothing but family law, divorce, family law issues. This video is to assist you in filling out the judgment. Not an entire judgment packet, but the FL 180 judgment form. If you see the video and see the form on the video in front of you, fantastic. If you do not, there's a link below. Click on it, get the form, put this form in front of you while I go through it, because you're going to want to be looking through it as we go. All right, folks, just like every form, your name and address and telephone number go at the top. Fax number if you want to include it, email if you want to include it. Then you put your name there as attorney for, because you're acting as your own attorney. If you're filling out your own paperwork, put your name there. Then the next line is Superior Court of California, County of, and you're going to put the county name of the county you're filing your forms in. Then the address of that courthouse, and I realize I've misspelled Orange there. It's misspelled on all of them. I do apologize for that. Then in branch name, you're going to put the name of the specific branch name of the court you're filing your paperwork in. It may or may not have that name, but you can Google that and find out the name of the court that you're filing your paperwork in. Just for example, in Orange County, California, the family court is called Lamoureux Justice Center. In LA, the Central Court is called Central. Very tricky. All right, folks. Next box down, lists ask for the petitioner's name and the respondent's name. Again, the petitioner is always the petitioner. If you're confused, look on the original summons and petition. You'll find out who the petitioner and the respondent is. And then your case number is over there to the right. All right. So, is this a judgment you're putting together for a dissolution of marriage or domestic partnership? Mark dissolution. If this is a judgment for a legal separation, mark legal separation. If this is a judgment for an annulment, mark nullity. Let's go with the standard. This is probably a dissolution judgment. If this is a status-only judgment, and if it is, you will know that because you will have bifurcated the issue of the status of your marriage, which is the fact that you are married or the fact that you are single. That's status. And you've separated that from all the other issues, property, your real estate, your custody visitation, your spousal support, domestic violence issues, if there are any. You have separated all that out. Why do we do that? Because some people want to end the marriage before they go through all this other nonsense. Say your divorce has been going on a long time, a couple of years. Judges would be happy to, and it looks like it's going to go on for another year. Judges will be happy to bifurcate the status of your marriage and return you to the status of a single person so that you can move on with your life. Heck, you might want to get married to somebody someday. You can't get married until that divorce, until the status of your marriage ends. All right. Or let's say you have religious reasons and you don't want to date anybody else until you're divorced. That's one reason why you might want to get divorced. And like I said, if you've been going through a divorce for a while, a judge would be happy to do that for you. But you'd have to bring a motion and get the okay to get that specific judgment done. And if you need that, talk to an attorney about bringing that motion. That's something that our firm would do for you if you wanted us to do that. Of course, we would charge you the fees to do that, but that is something that we could put together for you wherever you're at in California. Okay, folks, let's presume this is a regular judgment. And if that's the case, you don't need to mark any of these. Just for side note information here, if it was a status-only judgment, you'd mark status-only. If this is a judgment after you've received a status-only judgment, and you're asking the court, well, no. Okay, let's say it was a status-only judgment earlier, and now you're asking the court to give you a judgment on all the remaining issues. That's the bottom one, judgment on reserved issues. But let's say, for example, you're asking the court to give you a judgment on certain issues, but reserve on other issues. We do that too. That comes up every once in a while. And if that's the case, you'd mark that box. My guess is And more than 90% of the judgments, I'm guessing, I'm estimating, in my experience, are regular judgments that include everything. And if that's the case, don't mark any of those boxes. And you will see right down here, date, marital, or domestic partnership status ends. Do not put a date in there. If you get the wrong date, this paperwork is going to be returned to you because you've got an incorrect jurisdiction date on there. If you want to put a date in there, I would advise that you talk to an attorney before you do that. My advice is to leave it blank. If you leave it blank, the clerk is going to stamp that with the appropriate date anyway. And the clerk's going to put the earliest date possible to get your judgment done. Let's say, for example, you've been going at this for 2 years. The clerk's going to date that the day she gets this, because there only needs to be a 6-month and 1 day waiting period. If you are real on the ball and you and your spouse put this together and you get it done in 2 or 3 months, your status date will be about 3 months in the future. It needs to be 6 months and 1 day out from the date jurisdiction begins. So, my advice again, leave it blank. The clerk will put the date in there for you. All right. If there are restraining orders in your divorce case, you're going to mark 1, and you're going to mark the appropriate information here. And you're going to put the expiration date over where it asks for it. Again, most judgments don't have restraining orders, so I'm going to leave that blank if there's no restraining orders. Okay, so number 2 reads, this proceeding was heard as follows, and it depends on how your case has gone. So if you did a default or uncontested, so you either took the other party's default and you're at the end of the case and you're getting your judgment done, you can mark this box. If you are working together on getting this done, you can mark this box. A 2336 judgment, by declaration under Family Code Section 2336, is you're both working together and you are submitting all of your 2336 requirements, statements, as part of your judgment. This is not overly technical, but you're likely not going to fill that one out or mark that box unless you know exactly what you're doing, and I would get some advice on that before you do that. Probably if you're putting your judgment together on your own, default or uncontested will work. Now, if you went to court and you went to trial and you had all that and it was contested, you'd mark contested. Or if there was an agreement completed in court and you're going to attach the agreement that you got in court to this judgment, you could mark agreement in court, then mark the date and the department you were in and the judge and all the people that were present. If this is like most of these judgments that are being filled out by the party themselves, it's probably a default or uncontested, so you'd mark that box. Moving on. Number 3, the court acquired jurisdiction of the respondent on date. The date you're going to put in that box is either the date the respondent filed a response or the date that the petitioner served the respondent with the original divorce paperwork. And you need to pick that. So you absolutely must mark box A, and then you need to mark 1 or 2. So if they filed a, let's see, oh, I'm sorry, up here. So you absolutely need to put a date in there of when the party was served or filed. Let's say, for example, you served them, but they've never filed a response. Then you'll put the date in there that you served the other side. Keep in mind, you need to do and file a proof of service of summons that shows that date that you served them. Okay, that's how the court clerk will know that that's the correct date. If you, if they filed a response, you can also use that date as the jurisdiction date. Okay, and what does the jurisdiction date mean? The court cannot give you a divorce, I mentioned this just earlier, unless there's a waiting period for 6 months and 1 day after a jurisdiction date. And you can either use the date they were served or the date that the respondent filed their paperwork, the response. All right, folks, moving on. The court orders good cause appearing. Okay, 4A, judgment of dissolution is entered, marital or domestic partnership status is terminated, and the parties are restored to the status of single persons. If this is a standard form you're using to end your marriage and it's connected to the rest of your judgment packet, mark 4A and 1 and leave the date blank for the exact same reasons we left the date blank up above. If you put the wrong date in there, it's going to get kicked back and you're going to have to redo it. If you leave it blank, the clerk's just going to write in the earliest date possible in there anyway. All right, folks. The next one, B, is on a date determined on a noticed motion, either party or by stipulation. So if you have gone to court and you picked another date and you want a different date, you can put that other date in on 2. It's pretty rare. If this is not a judgment for dissolution, let's say it's a judgment of legal separation, you mark B. If it is a judgment for nullity from an annulment, you're going to mark C. And the parties are declared to be single persons on the ground of. Now, if you get a judgment for annulment, you need to understand that there are 7 or 8 different ways to get an annulment, and none of them are, we were only married for a week and a half. Doesn't matter if you're married for an hour. If there's no proper legal grounds for getting an annulment, you have to get a regular divorce. A lot of people think that if I'm only married for a short time, less than a year, only a week, whatever it is, I can get it annulled. No. If you were forced into a marriage, you can get it annulled. If you got married before you were 18, you can get it annulled. There's several reasons. You want to look that up. But generally speaking, you're going to have to put that jurisdiction reason in there, whatever yours was. Okay? Fraud, force, age, whatever it might be. All right, folks. D. This judgment will be entered nunc pro tunc as of date blank. All right. You will have had to get permission to put a different date in here. Nunc pro tunc means back to a certain date. It means that you are asking for a judgment date back in the past. Why would you want this? Okay, so let's say, for example, you asked someone to help you get your divorce, and you thought the divorce was done, but it really wasn't done, and you went out and got married again. So now you're married to 2 people. Not allowed to do that in California. Therefore, you might want to bring a motion with the court and get a date prior to your new wedding date so that your new marriage is valid. And that can be done as long as there's a good reason, really good reason, why you didn't know you weren't divorced. I've brought that motion several times, and I have won on that motion every time. I'm not going to bring that motion unless it's absolutely necessary. You should know that, judges are humans too. They want to help. They want, especially family law judges. The greatest majority of family law judges are just super people. They big hearts. They may not seem like it. They may not look like they've got a lot of patience, but they wouldn't be sitting on that bench in a family court if they didn't care about kids and care about families. And I mean that wholeheartedly. I've been doing this for 20 years, and that's my, I've run into a couple judges. It's true that I think don't care or don't like what they do. But the vast majority of the family court judges genuinely care about, especially kids and families. So if you walk in there with a good reason why you are married to 2 people and you want to get your first marriage nullified, or excuse me, you want to get your first marriage divorce dated back to a date prior to a second marriage so that you can make your second marriage valid, they'll do it. They will do that. Again, not automatic. You got to have some good reasoning, and you're going to need to be standing in front of a judge to get it done, but you can. Okay. That's rare, and you're going to have to figure out another way to do that. By the way, if you want to do that, that's a motion that you're going to need to bring. We do that. Of course, we would have to charge you for our time and our whatever we're going to do for you to do that, but that's a pretty technical thing, and you are going to want some legal advice to get that done. All right, folks. E, judgment on reserved issues. I mentioned this above. If you already have a status-only judgment, and this judgment is for all the reserved issues, you're going to mark E. Again, not likely. By the way, I'm just going to leave this one marked up here, A and 1, because that's 90% or probably even more than that percent of judgments. I'm going to go on to F, the petitioner. This is important. The petitioner's name or the respondent's name, former name, should be restored. So if you are the respondent or the petitioner, whichever one, and you want your name returned to the name you had before you got married, just mark this box and put in the proper name. So your name's Jane Doe now, but your real name before your maiden name was Jane Ann Smith. If you want to return to Jane Ann Smith, put that name in here and make sure you mark whether you're the petitioner or the respondent, and your name will automatically, part of the judgment will say your name is restored to this other name. Then later, you're going to get a certified copy of this judgment. You're going to take it to the DMV. You're going to take it to Social Security. You're going to take it wherever you need to take it to get your name legally changed back to Jane Ann Smith. All right, folks. G is jurisdiction is reserved over all other issues and all present orders remain in full force and effect. All right, so if you're marking that box, that's because you are asking for a status-only judgment and you want the court to maintain jurisdiction over all the other issues. That's when you use that. Let's go on to H. This judgment contains provisions for child support or family support. Each party must complete and file with the court a child support case registry form, FL 191. I have a separate video on that form. That form must be submitted within 10 days of the date of this judgment. And that's if there's a child support order in here. The parents must notify the court of any change in the information submitted within 10 days of the change and file an updated form. So if you file this 191 because there's a child support order in this judgment and then later you move, you need to file another one. If you change your phone number, technically you're supposed to fill out another one. So if there's any changes, do it. All right, folks, so mark those boxes as appropriate. And we're going on to page 2. Okay, so case name at the top, I just put Doe, last name. Oh, by the way, you might also see and wonder what the heck it is. You might see Irmo. A lot of cases, almost invariably I'll put Irmo Doe or Irmo Smith, whatever the last name is. Irmo just means in re marriage of. It's a legal connotation that we're dealing with a family law case, marital case. All right, folks, number 4 at the top. Children of this marriage or domestic partnership are. So if you have kids, list them in there, their names and their birth date. If you have more than 3 kids, it's not going to fit on this form. So do an attachment, a lined piece of paper, and do an attachment that lists all the other kidders. If you don't have kids, obviously this is all left blank. Let's presume we do have kids because it's good for the next set of boxes. J, 4J is child custody and visitation, parenting time are ordered as set forth in the attached. So if you have a written agreement, a settlement agreement, or a stipulation for judgment, you're going to mark 1. If all you're doing is submitting a form, child custody and visitation order attachment, an FL 341, which I have another video on, then you're going to mark 2. and then fill out the FL 341 and attach it to this judgment. 3, stipulation order, child custody and visitation of children. It's an FL 355. I don't have a video on that form. The FL 341 is more detailed and a better form for these purposes. And you can use it the same way. So if you want to do a 355, that's okay. I recommend watching my video and doing a 341. All right, folks. 4J. 4 reads previously established in another case, case number, and court. So if there are previous custody orders in a divorce case or in a child custody case that you had in Arizona, you could put the case number and the court name in there. If it was in a different county, you can put the case number and then just put, Riverside County. Or Yolo County, or San Francisco County, whatever it might be. All right, folks, moving on to K. Child support is ordered as set forth in the attachment. Again, just like above, it's going to be, if you have a child support order, it's going to be in some form of an attachment to this judgment. If it's in a written and signed settlement agreement, then that might be the one. If you have a child support information and order attachment, FL 342, then you're going to mark that. I have a video on the FL 342. So that might be the way you want to go. You can also do it as a stipulation to establish or modify child support order. It's an FL 350. That's the form you would use if you're in a I'm not even going to go there. So just I recommend using the 342 if you can. And then again, if there's a child support order in previously established in another case, could be in the Department of Child Support Services, you're going to mark 4 and you're going to give that case number, because a Department of Child Support Services case number would be different than your divorce case or your legal separation case. And you're going to name the court. Okay, real simple. Moving on to I, and that is a spousal support, domestic partner, or family support court order. Okay, 1 says reserved for future determination as it relates to petitioner or respondent. So if you're asking the court to maintain jurisdiction and reserve the right to give one of you support later, you can mark 1, and then whichever box you want the court to be able to give spousal support to later. So if you're the petitioner, you might want to mark reserve for 1. If you want to reserve it for both of you, you can mark both boxes. If you want the court to terminate the right to order spousal support for 1 or both of you, you're going to mark 2. And let's say you want the court to terminate jurisdiction to order it to the respondent. That could come up, and that would be ordered, for example, if you are doing a default judgment and the other party never responded, never filed paperwork, never was involved. You could terminate the court's jurisdiction to award the respondent spousal support. You can mark 3 if you're agreeing to spousal support or partner support order that is in an FL 343. Again, I have a video on the FL 343 if that's the form you're going to attach. And then again, if you have some kind of written stipulation or an agreement that you both signed, that would be 4. And if there's some other place that you have, that you have orders for spousal support, you'd mark 5, other. So I'm going to move on to M. M says property division is ordered as set forth in the attached. So if you have some property agreement that you have signed and or some written agreement and it's got everything in there, child support, spousal support, how you're splitting up your property, you'd mark 1. If you are using a property order attachment, FL 345, which I have a video on, you could mark that. I also recommend potentially other. Okay, folks, now we're on M, property division as ordered, set forth. Let me get rid of these notes. Okay, so you're going to mark M. If you have property that you're dividing in your case, then you're going to mark M. Now, there's a few different ways you can do this. One, you can do it as part of a written settlement agreement that you guys have put together, that you guys both sign, and it's a full settlement on all the issues, also called a stipulation for judgment or an MSA, marital settlement agreement, or that's the old school version. But if you have that, then you would mark 1. If you are dividing your property as you wish to divide it, as you've spelled out on a property order attachment for judgment on FL 345, that's fine. I have a video on that. I also have a video on an FL 160. If you do that and you want to use the 160, you can mark it FL 160 under other, under 3. I like the FL 160 if we're going to do that, if you're going to divide property, because that's a cool form that allows you to put the value of an asset that the petitioner's taking in the petitioner's column, and you can put the value of a different asset that the respondent is taking in the respondent's column, and then add them up as you go. The reason I like that form is because it very easily defines who's getting what piece of property, who's getting what chair, who's getting what car, who's getting the house, whatever you've got. And then it's easy to total at the bottom and make sure that they're both equal. Because keep in mind, the judge only has the authority to divide property equally unless you are both signing a stipulated judgment agreeing to property divided in a different way. For example, if one of you is taking 80% of the property or 80% of all the value of all your assets, and the other party is only getting 20% of all the assets, you're going to have to get approval for that. A judge is not going to do that on their own. You're going to have to go to court for that. Or have a stipulated judgment signed by both of you that spells that out clearly. All right, so that's, now let's move on to N as in Nancy. Attorney's fees and costs are ordered as set forth in the attachment. So if you are agreeing in your judgment that one party will pay for the attorney's fees of the other, you can spell that out, and you'd mark box number 1, and you'd put it as if it's in a, if that agreement's written in a settlement agreement or a stipulation for judgment or a marital settlement agreement or something that you have attached to the judgment, you'd mark 1. If you are using the attorney fees and costs form, the FL 346, you can use that form also, and you would mark 2. And if it's neither of those, but you want to just spell it out right here, you can put something like respondent agrees to pay petitioner $9,500 for, as in for attorney's fees. You can spell it out right there and keep it real simple. If there are no agreements on attorney's fees and neither of you are going to pay attorney's fees for the other side, leave it blank. Quite simple. Now, if there's any other issues, you can spell that out in the other box. I would recommend that you get some very specific legal advice on that if you're going to do that. If you're going to put something in that box, I would get some legal advice on that. All right, folks, then you don't sign this judgment. A judge signs this judgment. So the judge is going to, or the judge clerk will put a date on the left and the judge's stamp or signature to the right. And you don't absolutely necessarily have to, but if you know exactly how many pages are attached to the entire judgment, which would be all the child support stuff, the property stuff, any marital settlement agreement or a stipulated judgment that's all typed up, whatever forms you have attached to your judgment, if you know exactly how many pages there are, you can put that in here. If you don't know exactly how many pages it is, don't put a number in there. And that is it. That is the FL 180, the judgment form. Remember, you are never going to file an FL 180 alone. This judgment form comes with a whole pile of other forms attached to it typically. So if you're trying to file an FL 180 on its own, you're doing something wrong. All right, folks. Thank you very much for watching my video. I hope that was helpful.